Good morning, friends. We all are aware about the movie Chris, where Hrithik Roshan is blessed with special powers. We have seen in that movie that Hrithik Roshan was so powerful that he can read a particular book, maybe running into 200, 300 pages, probably in few seconds. But then, is that true for income tax authorities as well? Let us discuss this issue in light with certain judicial pronouncements. We all are aware that in case of section 153D, prior approval of JCIT is mandatory if the AO is below the rank of JCIT and the orders are of the nature referred to in section 153A subsection 1 clause B or section 153B subsection 1 clause B. What has happened in a case before the Allahabad High Court was, on a single day, JCIT has granted approval to 85 cases. The Honorable Allahabad High Court observed that it is humanly impossible that 85 cases are granted approval on a same day. The Allahabad High Court observed that law requires that the approval is required to be obtained for each assessment year. The word used, each assessment year, in section 153D has to be given due respect. Separate draft assessment order for each year is to be sent. Separate approval for each assessment year is required to be obtained. The process of obtaining a common approval for 85 cases is not permissible in law. There has to be an application of mind, and the application of mind should be visible from the approval which has been granted by the approving authority. Similar case came before the Honorable Delhi High Court. What has happened in this case was, according to the draft assessment order, the assessed income was 16 crore rupees, wherever as per final assessment order, the assessed income of 1 crore 50 lakhs of rupees. It was observed by the High Court that had the sanctioning authority verified the case records, compared the draft assessment order with the assessment record, probably he would have noticed that this is a serious lapse, more precisely an important addition of 15 crore rupees which was reflected in draft assessment order found missing in the main assessment order. This is a clear case of non-application of mind. One more case came up before the authorities where on a single day, approval of 45 cases was granted. It was held that it is humanly impossible that a 45 case records can be verified on a same day. There was a case where a common approval was sought for all the assessment years in question. Tribunal has held that if the approval is granted on a day on which the approval is sought, in that case it is difficult to believe that the concerned authorities has gone through all the case records. He has perused the search material, he has perused the responses of the assessee, and after applying his mind, he has granted the approval. The authorities have held that though the detailed reasons are not required to be mentioned in an approval granted, but that the approval granted must contain at least those words which endorses application of mind by the approving authority to the reader of that particular approval. If it is observed that approval is granted mechanically, approval is granted without application of mind, in that particular case, it would result into the quashing of entire assessment. The judiciary has also observed that the duty of granting approval is a very serious duty, and the authority granting approval has to act as a quasi-judicial authority, and he has to peruse the records and grant the approval. I hope that this judgments will be of your benefit. With this note, I take a leave of yours for today. I will see you soon in the next video. Thank you.